My
Fraudulent
client is
theft only.
pursuing a claim of identity theft with the Flint police. And sir, you can laugh about it, but if my client needs to do a police investigation, he needs evidence of the debt and where it came from.
I
What
don't
are
think
you
he's saying
talking
is
about?
It's not even
We're
fixed. You
talking
still have
about
an
a judgment from
obligation to have the
2011.
evidence to collect.
We have a judgment from 2011, and your client, the only reason your client is now objecting is because we finally hit on a garnishment.
When a debt collector finally lands a garnishment after years of trying, that is usually the moment people start paying attention. Today, in Michigan's 67th District Court, Judge David Goggins is hearing from attorney Kevin Miller, who appears on behalf of Terrell Cooper and is now arguing identity theft in connection with a judgment that dates back to 2011. To support that claim, Miller points to a deceased attorney still listed in the court record as evidence that his client never received proper notice, and he brings 3 separate motions before the court at the same time. The problem is that Terrell Cooper had 13 years to raise those concerns and chose the very week the garnishment hit to finally do it.
And then I believe there's also a motion for you to recuse yourself.
Okay.
That was not
Maybe I'll
filed
do
by
that
me.
one. Maybe I'll do that right at the bat. That'll be the easiest one. I need to get that one worked out. How about DLG and Associates versus Terrell Cooper?
Yes. Good morning, Your Honor. Kevin Miller appearing with Mr. Cooper.
Mr. Miller, and let's see, do we have what DLG and
Melody, Your Honor.
Associates?
Attorney
Miller,
Melody, Your
there
Honor.
you got it.
Morning.
Thank you. Morning. Let's see where we are. Motion to
I think we have a few motions up today.
okay. Which ones do we have? Help me out with that. I guess I have to sort through and see what we got.
Objection to garnishment,
Okay, yep, I got that
motion to set aside a default judgment, and then I believe there's also a motion for you to recuse yourself.
one. Okay.
That was not
Maybe I'll
filed
do
by
that
me.
one. Maybe I'll do that right at the bat. That'll be the easiest one. Actually, it might be. What there's a motion to recuse from which one of you guys?
Your Honor, Mr. Cooper filed this motion to disqualify. He filed the motions on his own, then came to me afterwards, so I'm helping him with these motions. I might also note, we have sent a subpoena to DLG trying to get information with regards to this debt because my client has filed a police report due to stolen identity. And we have never, ever received any evidence of this debt from 2011. And
Your
the
Honor.
police need a copy of that so they can do their investigation. And sir, you can laugh about it, but if my client needs to do a police investigation, he needs evidence of the debt and where it came from.
What concerns me is that you know that he's represented by, or that we're represented by counsel, DLG, and you didn't send the subpoena to us.
I did. I sent it out last week.
Okay, well, we haven't received it yet, and we've already argued the motion to set aside the default judgment. That was argued less than 2 months ago. The court's already issued an order on the merits on this.
I understand that, Your Honor, and I understand that, counsel, but there are some issues here with regards to my client on a number of occasions was reaching out to an attorney to get assistance with this. Come to find out this poor gentleman had passed away last year, and his information was constantly put on the notice for Van Velde, and this gentleman passed away last year. My client had reached out to them and never received a response. So I do believe that my client does have after finding this out, my client does have a valid argument to say, hey, listen, I've tried to reach out to you and I've never got a response, partly because the gentleman that you had listed on the register of actions is no longer alive, sadly. My client has never received any notification, any documentation of the debt in principle. My client is trying to work with the City of Flint Police to investigate this, and all we're doing is looking to get the information of where the debt came from, who accrued it. I have credit reports that show that this debt was never on my client's credit report. And my client's credit report goes back to 2007. This debt has never been on his credit report. So we believe, actually, and the police do believe, that there is an identity theft here, but they need a copy of the debt and where it came from and documentation of the debt so they can investigate it, so they can show that the debt is not his. And I know that you've already taken a garnishment and you have that ability, but until my client gets a copy of the debt, My client can't go to the police and argue that the debt is not his and prove evidence that the debt is somebody else's, and they put it in my client's name.
Well, you just made a representation that the police believe him. I've seen a copy of the police report, and there's no such statement from the police. We're talking about a judgment from 2011. There's been tax garnishments, judgment liens, periodic garnishments, motion to renew the judgment. I mean, he's been on notice a handful of times. Even the court sent out a judgment lien. And it's all to the same address that he's listed on his motion to set aside, again, his objection, and his motion to relieve the judge. You can't tell me that he hasn't been put on notice of this judgment. This motion's untimely. The garnishment objection is improper.
Let's deal with each one, I guess, first.
Yeah.
With the motion to set aside the default, I have heard that motion, and quite frankly, I denied that motion back. It looks like the last one, February 10th, 2026. Motion to set aside judgment was denied. It looks like it was filed way before that even. That's where I'm at with it setting aside the default. I've already ruled on that. That motion's denied. If I have to deny it again, but that motion's already been heard. Motion to set aside, denied. And that gets us to two motions. I got the motion to the objection to garnishment, and I guess the motion to disqualify myself. And I guess I'm Mr. Miller, for my sake, maybe that's the one we need to look at first. It says that prior to my appointment, this is 20 some years ago.
Yeah.
I honestly, whether I did or not, I didn't do much work other than personal injury stuff, but specifically, he says I represented him in the retired Honorable Judge Michael McCarra's courtroom.
Man, that's a name I haven't heard in a while.
I know it, and and I'm not sure quite frankly, what he's talking about. It says approximately 96 to 97 in the matter of rental agencies trying to obtain a judgment. During the course of reputation.
And Mr. Cooper, in speaking with him, was worried that because you'd represented him before, that there might be some bias here.
That I represented him, or I represented
Yes, you represented him.
Yeah. You know what? I don't even remember any of it. So, quite frankly, I don't see that there's an issue. And unless Mr. Meldy is going to object to it, me continuing with it, I don't think he's going to care either. If there was something, so it was like 20 years,
Yeah.
I don't even know. I honestly, I don't know anything about it. But if you want me to recuse myself, I guess I'll consider it, but I don't see any reason to.
I don't see any
myself.
need to.
Okay. All right, so the motion to disqualify is denied. And for your sake, Mr. Miller, I don't even remember it, quite frankly.
Okay.
So, and with respect to now, we're just on the objection to the garnishment. What do you, Mr. Miller, help me out with that one. Let's just narrow it right down to just the objection to garnishment. I understand there's maybe some claim that there's some.
My client is pursuing a claim of identity theft with the Flint police due to the fact is that my client does not have any evidence that this debt was his. I understand that the court has already entered a judgment. My client has already argued the last time we were here in February that he never received notice of it and didn't know about the debt. Well, my client has already been garnished once. They know they can get him whenever they want him, but my client is simply asking at this point to get a copy of the debt to find out where it is. And nobody can provide any evidence of this debt that actually exists. And my client would like to have that. I mean, if DLG is saying we've got this, that we have this debt that he owes on, there should be some documentation with regards to it. My client is simply asking for that so he can do, at least at a minimum, get an investigation into identity theft to find out where this debt is from. As I stated, DLG and whoever had the debt before, I'm assuming DLG is a debt collection company that snatched this debt up from somebody else. And my client and I have gone through his credit reports, everything. There is no debt that reflects the amount that was owing as of the date that the judgment was entered of $17,848.21. There's no debts even remotely in that amount appearing on all three of his credit reports. And so my client from the beginning has said, hey, at least send me a copy of the debt. My client's never received it. If he wants to try to get rid of this or find out who actually had the debt, my client just needs a copy of the debt, and DLG acts like they don't have to give it. My client should have a copy of the evidence of what he's paying for. That's why we've sent a subpoena.
Melody, I guess there's a whole different. I know the judgment is still sitting here. Is there some documents or something that I don't? Do you have something that shows that what was over?
Well, again, as he was referring to, that this was previously counsel Jeffrey Van Hatten. We took over from him, and I believe Van Hatten took over from a previous attorney. But even looking at the record of actions, shows that the defendant was properly served. By alternate service. So would have been put on notice. I mean, I can try to get whatever documents may be out there, but again, we're talking about a judgment from 2011 that he's been put on notice numerous times, and only now he's coming up with this defense of identity theft and making all these self-reports. I don't know, it just seems a little too convenient now that we're actually starting to collect on a judgment from 18 years ago.
I mean, it's awful convenient to come in here and say, we got a judgment, but you've got no evidence to back it up. I mean, my client is trying to clear his name, at least to have the police investigate it. And the response is, well, it's 20 years old. We're not going to do it. I mean, if you take over a case for someone, you should have the evidence to proceed to it, not just say, pay me.
No,
we have a judgment that says it.
Yeah, I appreciate all the argument from actually both of you, but Mr. Miller, it's just clean answer is it's just there's a judgment outstanding that's an old judgment still sitting there. That the money's owed, so for them to proceed with a garnishment, they've got every right to do that regardless. I've got a proper judgment. I've got an order in the file that says there's a judgment. I've ruled on things, but there is a point in time where, gosh, and not your fault, Mr. Miller, but your client is. Some of this he should have taken care of way long time ago, and he's getting into a spot where records are kind of disappearing. And I'm not saying that Mr. Meldy, if he's got stuff, he should give it to you. I think he can do that from the practical side, anyways, if he's got it. But
yeah, I mean, I'll comply with the subpoena that we receive as much as I can. But I can't guarantee that I'm going to turn over documents because, again, talking about a case from 2011, my client, debt collector. And we're the third attorney on this case. So we just came in to collect. That's not a defense,
though.
I don't think he's talking about.
It's not a defense.
We're talking about a judgment from 2011.
To have the evidence to collect.
We have a judgment from 2011, and your client. The only reason your client is now objecting is because we finally hit on a garnishment.
Okay.
Well, it's the only time he's raised any issue.
I put both of you out of your misery right now. Let's just the objection to garnishment's invalid at this point. So, and then hopefully both of you can kind of work out getting a copy of the debt, because I do, I understand from that side. Apparently, there's a subpoena floating around. Mr. Miller, is that what you did?
Yes, it was sent out last week.
Okay.
Mr. Cooper came into my office last week to retain me.
Okay, so I'm sure Mr. Miller's going to get what he's got. We'll just let that play out. So if I can get, let's see, maybe I don't know if I've got an order, or I'll fill out an order for the garnishment. Who wants to do orders for me?
I'll do them because we filed. Mr. Cooper filed the motions. I'll do it.
Okay, Mr. Miller, thank you. And if there's something else I can do, getting documents, Mr. Miller, I don't mind.
All right, thank you.
All right, guys, thank you.
Judge Goggins denied every motion, allowed the garnishment to stand, and acknowledged that records tied to a debt from 2011 are not easy for anyone to track down at this point. Whether Terrell Cooper is truly a victim of identity theft or simply someone who waited 13 years too long to raise the issue is now a matter for law enforcement to sort out, because from the court's perspective, the debt remains owed either way. And if you enjoyed watching this one, subscribe and leave a like.